All right, well, joining me now in studio to dive deeper into the recent court rulings is Ken Klukowski, a former senior counsel in the Civil Division of the U.S. Department of Justice and a former special counsel in the White House's Office of Management and Budget. He has also litigated constitutional cases in the Supreme Court. Ken, glad to have you with us.
Thanks, Tony. It's always great to be with you.
Okay, in just a moment, we're going to be joined. I'm going to talk to Coach Kennedy. So I really want to jump into the Dobbs case, and we're going to be able to unpack some of these cases. I made a comment earlier about this term of the court being one of the most favorable to the Constitution probably in my lifetime. Can you take us back to a time when we saw a term of the court more favorable to the Constitution?
I agree wholeheartedly. The only things I can think of even on this level, you'd have to go back to 1935, I think. I can't think of any year. That certainly predates me. I can't think of any year since then. Even 1936, where we were still holding strong on some issues, other issues started to go by the wayside as FDR was shaping the Supreme Court to the left. And then 1937 becomes what liberal historians call the switch in time that saved nine, where two justices who had been voting conservative got worried about FDR's court packing plan and switched to liberal votes to try and exactly. Of course, they turned out, it shows judges tend to be lousy politicians and vice versa because the American people were rejecting it. And so that plan wasn't going anywhere, but we've been stuck now with the decisions that they started in that year. But I think you have to go back at least that far to find the kind of victories we've had in the series of the past week.
Wait, let's focus on Dobbs here for a moment then. So what, in your opinion, as a constitutional attorney, having read through this opinion, what is the most significant aspect of Dobbs?
It was an issue of who gets to decide these things. It was, in a way, fundamentally, it was separation of powers. It was that our form of government is a constitutional democratic republic. That means the people decide things for themselves. We're a self-governing people. And that the court was saying that only the American people can put something in the U.S. Constitution. And when the American people do it, it's our job to correctly interpret it and correctly apply it. When the American people do not put something in the Constitution, it is our job as unelected and unaccountable judges to step aside and let the voters speak through their elected lawmakers.
One of the passages, it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by the citizens trying to persuade one another and by voting. That's what the Constitution and the rule of law demands.
That's exactly right. And that was Justice Alito there, and then also quoting a dissenting opinion from long ago from the late Justice Scalia, and that's how long this issue has been going on. So we have had a half century of judicial usurpation and shutting down democracy on this issue. The court took the principled stand of saying this is left to the people. It is not our job.
I know that the court, in the majority opinion, stated that this is a dealing with abortion, but when you go to the underlying judicial philosophy, really of a facade of rights created out of thin air, this is returning the court to being tethered to the Constitution, is it not?
It is, and that was a huge part of Justice Alito's decision, where he said that the way we have interpreted the Constitution for almost a century now. He said if something is in the text of the Constitution, like if the word abortion showed up in the Constitution, that would be one thing. He said the framework we've developed over roughly a century is that if it's not found in the text of the Constitution, as we look to the structure of the Constitution in history, the question becomes, is the purported right, the claimed right, is it both deeply rooted in the history and traditions of the American people, meaning did the framers of the Constitution recognize it in the 1700s, and has it been universally seen as a right, like the right to be able to have children or the right to be able to marry? And is it also implicit in the concept of ordered liberty, that you're not really in a free society if you don't have the right to do this? And he says that history and ordered liberty concepts, those are the only criteria, and you have to check both boxes to say that anything could possibly be a constitutional right if you don't find the word in the Constitution itself.
And it's not there.
Correct. It's not there.
So what else has the court created? And we're going to go to a break, so we're going to finish this a little bit later, but just be thinking about this. What else has the court created? I mean, they haven't used that framework that Alito laid out there. I mean, we've got these things found in the shadows of the Constitution. Usually in the shadows are spiders and boogeymen. But anyway, we got to go to a break, and then stick around, Ken, because we're going to talk more in the D block.